Fair housing law prohibits discrimination based on protected characteristics, including familial status. Sometimes a landlord's policy doesn't discriminate by expressly using the protected characteristics, but it still has a discriminatory impact. Human Rights Commission versus LaBrie considers whether an occupancy limitation discriminates based on familial status. In the early 80s, Linda and Ernest LaBrie purchased Limehurst Mobile Home Park and later transferred the park to their corporation. The park had 33 mobile home lots. Residents typically owned their mobile homes and leased the land from the park. When the LaBries purchased the park, Limehurst had only adult residents. Starting in 1982, the LaBries included an adults-only occupancy provision in the land lease. Lessees were prohibited from having children under 18 reside in their mobile homes. At that time, Vermont's fair housing law didn't prohibit discrimination in mobile home lot rentals based on familial status. In 1989, Vermont's fair housing law changed. The law now prohibited discrimination in mobile home lot rentals based on familial status. That same year, the LaBries changed the occupancy provision in the lease from an express prohibition on children to a neutral two-person maximum. Scott and Luanne McCarthy bought a mobile home in the park, and after the fair housing law was amended, they had an infant son. The LaBries repeatedly told the McCarthys that they couldn't live in the mobile home with their infant. The unrelenting demands to vacate left the McCarthys humiliated. They moved out. The McCarthys filed a complaint with the Vermont Human Rights Commission. On the McCarthys' behalf, the commission sued the LaBries for violating Vermont's fair housing law. The trial court concluded that the LaBries unlawfully discriminated against individuals with minor children. The LaBries appealed to the Vermont Supreme Court.